This could be the game changer for your rights. After years of setbacks, the Supreme Court is reviewing 5 major Second Amendment cases. Cases that could reshape our constitutional landscape forever. So, are we witnessing the dawn of a new era of freedom or the final blow to our rights? Stick with us, because the outcome is closer than you think. Chapter 1. The Big Challenge. These 5 cases aren't just any cases. They're a direct challenge to years of restrictive gun laws. The court has been quietly watching lower courts mishandle the Bruin Standard for 2 years, letting confusion reign. Now, they're poised to strike. Let's break it down. The Bruin decision, which should have clarified gun rights, instead sparked chaos. The Ninth Circuit is claiming that magazines aren't considered arms under the Second Amendment. The Seventh Circuit says AR-15s aren't protected because they're too common. The Third Circuit is making up new tests that would leave our founders in disbelief. So, what is the Supreme Court going to do about it? Chapter 2. The Supreme Court's Power Play. The court has been quietly collecting these cases like ammunition. Why? To make a move that will settle the score once and for all. Typically, the court looks at 1.3 gun cases per term. But 5? This is unusual, and it signals something big is coming. Inside the courtroom, it's no debate fest. Just 9 justices, no staff, and no distractions, making decisions that will impact every American. They don't argue. They listen, vote, and decide. For these cases, 4 votes are needed to move forward. It's simple math, right? But here's the twist. Chief Justice Roberts has a history of avoiding controversial 5-4 splits, which could result in narrower rulings that leave room for states to keep restricting rights. Will they make a bold stand or back down? Justice Barrett's concerns over sensitive places and Justice Kavanaugh's openness to certain restrictions mean we're in for a tense battle. So, which way will the justices lean? Chapter 3. California's Magazine Ban. First up, California's controversial magazine ban. If this case goes through, it could set a dangerous precedent for property rights across the country. California banned magazines over 10 rounds in 2016, but now they want to confiscate magazines bought legally during a court-ordered window in 2019. Imagine buying a car, only for the state to make it illegal 5 years later. That's what's at stake. When a state retroactively criminalizes property that was once legal, we're all at risk. If California's win stands, it could pave the way for other states to do the same. But the real kicker is the Ninth Circuit's decision that magazines aren't arms under the Second Amendment. That logic could apply to any firearm part, even ammunition. Chapter 4. Illinois Assault Weapon Ban. Then, Illinois steps into the ring. Their assault weapon ban doesn't just target accessories, it goes after the guns themselves, specifically banning over 190 models by name. These guns aren't just random firearms. They include popular models like the AR-15 and other semi-automatic rifles, which millions of Americans legally own. Illinois claims these guns are too dangerous and too common to be protected. But here's where the logic falls apart. How can a weapon be both too dangerous and too common at the same time? It doesn't make sense. Either these rifles are common, which means they're protected under the Second Amendment, or they're rare military-style weapons, in which case they wouldn't be used by millions of civilians. The data paints a very different picture from what the state argues. Over 24 million AR-15-style rifles are in civilian hands, and they're used in less than 2% of all gun crimes according to FBI statistics. So, the state's argument doesn't hold up. To make matters worse, Illinois isn't just stopping with banning certain models. they've implemented a mandatory registration of all currently owned firearms that fall under their assault weapon ban. This essentially creates a registry, a database of law-abiding citizens who own these firearms. And what's even more alarming, once that list is created, the door is wide open for future confiscation. This could be the first step toward a nationwide move to disarm the public, one state at a time. As the legal battles unfold, we need to ask, is Illinois overstepping its bounds? Or is this just the beginning of a larger strategy to dismantle our rights across the country? Could other states soon follow Illinois' lead and impose similar measures? The outcome of this case could set a dangerous precedent that goes beyond the borders of Illinois. And if the Supreme Court doesn't intervene, it might pave the way for more states to enact these unconstitutional bans. This case could very well determine the future of firearm rights in America. Chapter 5. The Prohibited Persons Trap. Next, we have a case that's making waves across the country. The Prohibited Persons Trap. This one focuses on how a youthful mistake can strip a person of their rights for life. A college student caught with marijuana could lose their Second Amendment rights forever, even if they've served their time and become productive citizens again. Once you've lost your rights, they may never come back, no matter what you've done since. This law impacts millions of Americans. The government opposes restoring gun rights to people who haven't committed violent crimes. Yet, the real question is, why are these nonviolent offenders stripped of rights without any real investigation into their actual danger? Chapter 6. Text, History, and Tradition. These cases represent an escalating clash between state power and constitutional rights. Will the Supreme Court follow through with the historical approach they've promised? We now live in a new era, the text, history, and tradition standard. This new lens is forcing the government to prove that their restrictions align with the historical practices of the founding era. Modern bans simply don't have a historical precedent, and the government can't create one. The Heller decision confirmed that commonly used weapons for lawful purposes can't be banned. That means bans on popular firearms, like AR-15 and their accessories, aren't just unwise, they're unconstitutional. Yet, lower courts keep trying to invent reasons to justify these bans. The Supreme Court must step in. The Second Amendment is clear. The common use doctrine defends our right to bear arms. In fact, this judicial rebellion is becoming harder to ignore. Lower courts continue defying Supreme Court rulings, all while the numbers paint a stark reality. The government must either enforce the precedent or risk losing its authority. Chapter 7. What's next? So, what's next? The Supreme Court has the power to change everything, but they must act now. If these cases are granted, we could be looking at the biggest Second Amendment victory in years. But if they back down, our rights may hang in the balance for decades. Remember, this is about more than just guns. It's about freedom. So, what's your take? Drop a comment below and tell us which case you think is the most important. Don't forget to like, share, and subscribe to Firearm Legal Briefing for more updates. The moment the justices announce their decisions, we'll be here with the full analysis. Stay tuned, Patriots. The fight isn't over yet.